Hey everybody, it's Tom Rawlings, Director of Georgia's Division of Family and Children Services, here today to provide you with a brief overview of what is going on in terms of child protection in our state. Really some philosophical and foundational principles on which we're basing this work. Give you an idea of where we've been and where we're going, especially in light of some new federal changes that are coming along. And so let's just get started. Let's start off with some real basic principles. We know that since time immemorial, the parent and the child, or the parents and the children, have been the fundamental family unit. And we expect that parents care for their children. We expect that they protect their children, and we also give them the liberty to do so. It is a fundamental right of the family to be together, and we don't get involved in that as a government agency unless that child is somehow unsafe. Traditionally, of course, before there were perhaps organized government child protection agencies, we relied on a couple of other layers of support for those families to keep children safe if for some reason the parent could not do so. If you had a parent who was ill, a parent who was not performing his or her parental capability work and was not exercising that capacity, then you had the extended family that would come in, and the grandmother or the Aunt Sally or whoever it may be, perhaps even a fictive kin, such as a neighbor who was almost like an uncle or a godparent. And those individuals would step in and care for children when the parent could not do so. You've also had, I think, for certainly several thousand years, ever since man and woman settled down in agricultural, sedentary communities and built governments, you've been able to rely on your neighbors. If you had a barn burned down, if you had a famine, if you had an illness in your family and couldn't go harvest your crops, the extended community would come in and help you out. And there was this system of mutual trust because they knew, your neighbors knew that you would do the same for them. And that same rule really traditionally applied to the raising of children in our community. If the family needed support, the community would come in and give that support to the family. Now, of course, we have, at least for the last 100 years or so, we've had government agencies that are actively involved in child protection. And what we, I think, have created is a system in which very often the government sort of takes on almost the primary role of protecting children from harm. But what we, I think, know works best is when government can support the family, to support the extended family, to support the community in protecting children. And so government has its role, but most of the time that role needs to be to help families with the services necessary to keep the child safe while keeping the family unit together. We know that if we need to be able to, if a grandparent has taken in a child, we need to be able to provide that grandparent with support, child care, perhaps financial subsidies to care for the child. And certainly we need to be building and helping to build partnerships within the community so that our agency is serving its proper role as one piece of a very complex and large child protection system that involves churches, mosques, synagogues, schools, community centers, community leaders, mentors, and thought leaders in the community, civic clubs, and you name it. So we're going to talk a little bit about how that is working here in Georgia and what we're trying to build. But let's start off with another fundamental principle. So we know that the children do best when they are able at a very young age to attach, and there's attachment theory is something that's been studied and discussed for many years, but children have a tendency to attach to the adult that is their caregiver. If that adult is a reliable, trustworthy, calm, capable parent or other caregiver, then that child will develop a feeling that he or she is loved, is cared for. They will be able to trust. They will learn to explore. They will develop self-confidence. But of course, on the other hand, if for some reason, I have to turn the lights on, so I have to do this. If for some reason the parent is not acting in that trustworthy role, perhaps due to domestic violence, mental health issues, chronic stress in the household, inattention, or if the child is bouncing back and forth between caregivers, for example, coming into foster care or being separated from the parent for a long period of time, then the child can develop significant issues that can result in developmental delays and mental health issues and a lack of ability to develop good, solid relationships. So what we try to do, I think, and what we all want for our families is for us to develop that parent-child bond, and a lot of our work in child welfare really should be centered around helping that parent to be the trustworthy individual, the reliable caregiver that a child needs to develop a really healthy sense of self. But we're going to talk a little bit as we go on about how this issue of attachment is not simply a question we think about when we decide whether or not a child should be removed from his or her home or his or her family because of safety issues. It also ties into when we do things such as terminate parental rights, what we do about a placement of a child with a foster parent. So we'll come back to some of that, but remember these basic principles. We also, I think, we have a lot of policies here at our agency. We do a lot of talking about, policies such and such, and basically what we're trying to do is we're trying to balance a lot of different factors. But I think we can kind of, when we look at our work from the time that we get an intake call that a child is perhaps in danger, all the way through deciding whether to reunify the child with the parent, to terminate the parent's rights and do adoption, to let the child return home or to be placed with a relative permanently. There are about 10 questions, I think, that are significant. The first question should always be, is that child safe? And whenever we make decisions regarding the removal of a child or keeping a child with his or her family, that's got to be the primary question. Safety has to come before all things. And when we talk about safety, as we'll do more in a moment, we're really talking about serious cases of safety. We can't always guarantee that every child is going to be safe from every potential risk, but we can ensure that children are safe from significant risks of emotional or physical harm. The other thing we always need to think about is sometimes we have situations in which a child may not be necessarily unsafe at this moment, but we know that if our agency does not help the family, that child is likely to come into our care in some way or another. Often this happens with children who have developmental disabilities such as autism, who have mental health issues, who are in trouble, perhaps running away a lot. And so while these types of cases such as juvenile delinquency and mental health are not our primary role, we're not the lead agency on these things, we do have an obligation, I think, to help out as much as we possibly can in those situations. When we talk about our work, we need to be really focused not on the parent's needs, but on the child's needs and the child's rights. And we'll come back to more of that in a moment. Certainly, the parent has the right to raise his or her children, if that can be done safely. That is a fundamental liberty interest. But when we think about what we're doing with regard to placement of a child or removal of a child, we need to think about the individuals to whom the child is connected. What is the connection between that child and the parent, between that child and a foster parent, between that child and a relative? How can we preserve those connections with, for example, siblings or with a favorite aunt? We also need to think about what the parent has done. Is this a situation in which the parent has simply been neglectful, maybe the parent has a mental health issue or a substance abuse issue that we can fix with our involvement? Or is this a situation in which the parent has done something so atrocious that the regular lay person, the regular reasonable person would say, this child needs a fresh start. This child should not be required to go back to this family. So the question then, of course, is, can this family be repaired? We also need to think, whenever we're taking actions, is why are we doing this? Are we doing this because it's something we feel is the right thing to do for the child? Or is it something that we feel that perhaps we have a policy or we have competing priorities, and we're sort of balancing perhaps not the child's needs and the parent's rights, but other philosophies and other policies that are out there. Another thing that we sometimes don't do a good enough job in child welfare is making sure that all the right people are involved in the decision. So for example, when we have a situation where a child has been in a home with a foster parent for quite a period of time, and there's discussion of perhaps moving to a different foster home, we need to involve not only our staff, but also the foster parents, the court, the child's guardian ad litem, the child's attorney. There are others, and for example, if there's a child has a mental health issue or a therapeutic need, we need to be involving the therapists and perhaps other agencies, other state agencies. And then that, of course, revolves, I think, back down to a basic question is, when we're making hard decisions about children, especially when those children are in foster care, but even when they're not, is this decision one that we should be making as an agency, or is this one that we should be making in conjunction with other partners, or one that should be made by the court? So we have been thinking a lot in Georgia about the implementation of this law that I will go back to here. It's called the Family First Prevention Services Act. Now, under traditional federal funding, going back 40 years or so now, federal government would basically supplement or subsidize foster care with federal funds. So if we had a child, it's often meant that if we brought that child into foster care, we would have more funds to be able to provide services to the child and to the parents, and really it was kind of bolstered our ability to serve that family. Now, under the Family First Prevention Services Act, which passed about 2 years ago now, we can use those same federal funds to keep children in their own communities if, except for the use of these funds, except for these services, we would have to bring the child into foster care. So it really gives us greater incentives to keep the children out of formal state custody. And so we can look at some things that we have been doing in the last year or so, 2 years really now, to begin to implement this act, which really takes effect in October of 2021. One of the significant things we've done is we passed a law last year in 2019 called the Temporary Alternatives to Foster Care Bill. And what that does is recognize that traditionally, when we have had a child who was not safe in the home, that what we might do is call the court up, because we can't remove children to a foster home without court approval. We would often call the court up and say, we believe this child is unsafe. Will you put this child in foster care? Now, again, we need to keep children safe, but simply placing the child in foster care is sometimes using a mallet to kill a fly, as they say. There are often things we can do short of a formal foster care placement that can keep the child safe. And in fact, many judges historically have asked the sort of questions, is there something what we can do? Can we do what we call a non-emergency dependency petition, do a protective order? And in fact, we often see that children who are removed to foster care, when we have the preliminary protective hearing, when about 3 days after the foster care removal, that the child may in fact go home under a protective order. So the more that we can do to preserve that child's stability at home by taking actions other than a full-blown foster care removal, that's the sort of thing we want to do. So this bill allows the allows the juvenile court at our request to implement some temporary protective measures to really to prevent trauma to the child or removal, especially to allow the child to be cared for by individuals with whom the child already has an existing bond or attachment, but also certainly to ensure the child's safety pending further court action. And the three big ones that the court can order are authorizing the child to be cared for by a relative or a fictive kin, such as a neighbor with whom the child already has a relationship, doing a protective order, and we'll talk more about that, or simply beginning the process of investigating the home so that we can then come to court in a few days and work the situation out. The difference in the law, I guess the changes in the law, was that it has always been the case that the court had to use reasonable efforts to prevent removal of the child. We'll come back to that in a moment. This law requires that the court determine whether there are reasonable alternatives to the removal of the child, and if so, whether there are temporary alternatives that will protect the child from harm while preventing the child from coming into the court's formal custody or our agency's formal custody. So as I said, there's three ones, or an order authorizing the care by the relative or fictive kin, a protective order, an order for defects to investigate, and then, so for example, if we have a relative or a fictive kin, the court can go ahead and order that the child stay in that placement with, say, for example, grandmother for a few days, and our agency in the interim does a very quick, thorough, but not full investigation, but fairly thorough investigation based on what's available that we can get done within 72 hours to make sure that person's a fine person to care for the child. There's also the ability of the court to order a protective order. So, to give you an example, one of the things is that you can order someone out of the home. This is actually something that's already done in family violence cases with regard to temporary protective orders. If you, for example, if a person is a family violence offender, the victim can go to court, ask the court for a temporary restraining order that will require the offender to leave the home, to stay away from the mother, to stay away from the children. We really should be doing the same sort of thing in foster care cases, or in child welfare cases, where the problem is one of family violence. Why would we remove the child, who is also a victim, along with the non-offending parent, and when we could remove the offender, the person who is creating the situation of domestic violence? We can also, of course, begin the process through a protective order of, requiring that the parent go get some counseling, that will require that we undergo some investigations, or that the parent, say, for example, work with our agency. And the key, of course, is that we're not removing the child from the legal custody of the parent, but we're not placing the child in foster care, but we are, I think, doing lesser steps that allow the child to be safe while we begin the process of working with the family. There are always, of course, concerns about due process. We, generally as a system, as courts and as agencies, don't want to make people do things without making sure that they have the right to notice and an opportunity to be heard. And of course, under our traditional foster care rules, if we request the court ex parte, or without anybody else's permission, we call up that judge and we ask for the child to be removed to foster care, we have to come to court within 3 days and have a hearing on that to see whether or not that is something that should continue. In this temporary alternatives to foster care law, it's the same principle. It's just the court has 5 days in which to hold that hearing. That those extra couple of days give the court and our agency the opportunity to fully vet whether this is a situation where we can maintain the family together, or whether we can maintain the child at least with a relative in his or her own community. So this is the kind of thing we're moving towards as we try to keep children safe, but not necessarily in our formal custody. Most of the time, these sort of temporary alternatives foster care cases are going to result in a longer-term court-ordered case plan or a longer-term court protective order in which our agency will be working with the family, either with the child back with the mother or father or with a close relative for a period of time. We'll try to work with the family to work out whatever sort of issues have caused safety concerns about the child. The parent has an attorney, the child has an attorney, the child has a guardian ad litem. Everybody is in court, so we have court oversight. And it's the kind of situation that really promotes keeping families together and keeping children out of formal foster care while addressing safety concerns and service needs. What we really are aiming for is, again, as I said, the traditional model was either you go into foster care or you're in what we call a family preservation case with only the agency involved. The parents in those cases don't have attorneys. The child doesn't have an attorney. There's no court oversight. We want more of a continuum of process in which we can go anywhere from having an agency-only family preservation case all the way up to foster care. The more of a continuum we have, the better outcomes we get, I believe. Now, let's talk a little bit about what we mean by safety. So the safety is not, let's see, we know that there are safety threats that occur to children all the time. The real question in child protection is not simply one of, is there a threat to the child's safety? It is a question of balancing the child's need to be with family, the child's right to be with family, the family's right to have their child in their custody. Oops, there goes the lights again. Against the safety threat to the child. So we look at, as an agency, we look at what are the safety threats to this child if the child remains in the home without some sort of intervention. What are the child's vulnerabilities, and what parental or caregiver protective capacities exist, or what's lacking? I'll give you a quick example. If you have a child who is an infant and mother has a severe alcohol or drug problem that truly makes her, she's not able to control her drinking, she's not able to control her drug use, her use of these substances prevents her from being at least providing the basic care necessary for the child. Then you have a significant threat because the child could in fact die for not being cared for well. You have a very vulnerable child, and you have a parent who is not able to control herself or himself to provide the care necessary. Now, on the other hand, what if that child were 16, 15, or 16? That's a different level of vulnerability. What if we were able to place the child and the mother together in a residential rehab facility where she can recover while being monitored? Then that is, we're boosting her capacity to be a good parent and also reducing the safety threat. So these are the kind of things we need to think about. And really our interventions are designed and should be designed to address all three of these. It's what I like to say, the crucible of reasonable efforts. We put these things together and we decide what to do. So when we talk about reasonable efforts, this is something that those of you who are already in child welfare know well. Federal law has for many years required us to use reasonable efforts to prevent removal of a child, to allow the child to go back home to his or her family, and whenever we have decided what should occur with regard to the child's permanency, to complete that child's permanency plan. So what we simply are doing is are we need to ask ourselves, is this an emergency? Is there something that we can do to keep the child safe? Or on the other hand, are we simply seeking compliance? I'll give you a good example. Many times when we have a case plan that's either for a child in foster care or even for a child who's still in parental custody, we'll put in things in that case plan that we expect the parent to do that we believe are good for the parent's future, good for the parent's capacity to care for the child. But the question, of course, is, are those related to the child's safety? And of course, the other thing is, we also need to think about whether or not what we're doing is actually going to keep this child safe and out of state custody and parental custody, or are we simply kicking the can down the road? So when we are thinking about the way we're doing our work, we want to make sure that we are thinking about keeping that child as close to his or her community as possible. We want to think about when we are looking at perhaps having a child who is not safe, what things can we do to make the situation safe? And that may be placing with a relative. It may be a temporary placement with a relative. It may be ordering somebody out of the house. It may be asking the court to order a protective order. But there is, as I said, a range of things we can do. One of the things we're doing in Georgia right now, the last couple of years, is we have begun what we call our Preteen Consultation. And in our Preteen Consultation, whenever our local staff believe that a child cannot remain safe in the home, we all get on a phone call with some of our state level experts, and we talk it out, and we say, is there something we can do? Are there some funds we can find? Are there some services we can provide? Is there a relative we could get to help out? Until we get the mother's situation or the father's situation reasonably safe. The other things we have been doing in terms of, we'll kind of go back here to the whole issue of two issues: safe threats, vulnerability, and protective capacity, and also back to this issue of attachment. So when we have a child who is in foster care, we think about using reasonable efforts to get that child's family situation to the point where the child can be safe in the home. And traditionally, that plan for returning the child to the home, which does occur in probably 75% of child welfare cases where children are in foster care, they generally return home within a reasonable amount of time. Generally, those particular plans are done, and they contain a number of steps the parent has to go through, including such things as substance abuse treatment, mental health treatment, counseling for the family, parenting classes. But the question is should not be, has the parent completed all of the case plan? The question really should be instead, have we, by what we've done, reduced the safety threat or reduced the child's vulnerability or increased the parent or caregiver's capacity to the point at which the child can return home safely? At that point, we could return the child home and then continue under a court-ordered case plan or a court-ordered protective order or aftercare until the parent, in fact, fulfills the case plan and thereby demonstrates not only is this child safe, but they can keep the child safe for the longer term. The other issue that I think which attachment comes up is the issue of placement stability. Too often, I believe, we see that a child will be in a foster home, and we have, of course, the obligation to look for relatives. We'll try to find relative placements quickly. But one of the things we don't do a great job of is think about the child's need for stability. Okay, so think about this: if you have to remove a child from the home, if you can quickly find a relative or other person with whom the child already has a strong connection. And if we can keep that child close to his or her own community and other relationships, friends, school, the things they do after school, then that's what we need to be doing. Sometimes we'll have a situation where a child comes into foster care, is with the same foster parent for a long period of time, and especially if they're younger, develops a very strong attachment to that foster parent. And then we find a relative, and of course we do have a preference for looking for relatives and considering relative placements, but oftentimes this relative may come forward after we have been looking for quite some period of time, or after we've already asked the relative to be considered. And by this time, many, many months have passed. The child has developed a strong attachment to the foster parent, and we are considering whether to place the child with a relative the child does not really know, because we've decided the child really can't go back home with the mother or father. We need to think about the attachment issues here. And so one of the other things we've been doing in terms of making sure our placement decisions are well thought out is we're piloting in some of our regions what we call our pause team. It means, it actually is an acronym, I can't remember what it means, but it means that before we go and remove a child from one particular foster home to place with another relative or to place in a different foster home, we need to stop, think, and really look at why we're making that decision. We also have some laws in Georgia that require our agency to give a foster parent or a relative caregiver, whoever has the child, and the child, if the child is over 14, notice of the proposed placement change and the opportunity to file an objection to that change, to have a court hearing, so that the court can help us walk through these situations. As I said earlier, remember, one of the big questions is, have we involved all the right to people in the decision, and is the decision one that we should make or one that the court should make? And when it comes to making sure that children have good, solid relationships, and when they're attached, that we don't mess up those attachments, that we need to make sure everybody is on board. So those are some of the things we're doing. And the last thing I want to talk about today is the other issue, which is, what do we do when we have a situation where a child really should not go back home? So I think that, as I said, we have probably 75 to 80% of the children that come into foster care will go back home. Generally, the issues we deal with are those that are solvable with the provision of services. They may not take a little bit longer than we want, but we are dealing oftentimes with children who are attached to a parent, who love their parent, who just simply want a parent who can care for them right well. So whenever we can bolster that parent's ability, we do so. But there are also situations in which a parent has done something so atrocious or has continued to do things time and time again that demonstrate that the parent simply is not going to be able to care for this child. Give you a couple of examples. One, of course, is a case of serious physical abuse where a parent has done just what the layperson would say is enough to really break that bond of trust permanently between parent and child. Or one of the others, of course, is where a mother especially has had numerous children, time after time, has been offered, has had children who are born addicted to drugs or born drug exposed, that we have offered that mother continually over time through the birth of several children the opportunity to get drug treatment. That drug treatment has been either failed or has been refused. We actually have the opportunity to decide up front, thanks to a federal law called the Adoption and Safe Families Act, that in those cases, reunifying the family or repairing the family should not be our goal. Our goal should be to help that child find, as quickly as possible, a solid, safe, reliable caregiver with whom the child can build an attachment, especially if that child is a very young child. And again, that goes back to attachment. If you have a parent who has demonstrated that they will not be trustworthy and not be reliable, then we need to make sure that child has someone on whom they can rely, whether it's a grandmother or an adoptive family. So the law allows us to really move forward toward TPR if the child has been subjected to aggravated circumstances, the child or another child in the family has been seriously assaulted by the parent, if we have repeat cases in which the other children of the same parent had their parental rights involuntarily terminated. And in such situations, we can ask our court up front to go ahead and put this case on a fast track to either termination of parental rights or to a permanent guardianship with someone such as a relative. We can do that, and when we go to that hearing, if we can show that the parent has unjustifiably failed to comply with a previous reunification plan, if the child has been removed from this home already twice and we've tried and we put the family back together and here we are for a third time, if there are any of the grounds for termination of parental rights, or if there are any of these aggravated circumstances, then we can move quickly, as I said, to TPR, or as you'll see here, you can place the child in the custody of a permanent guardian such as a relative. Then just to let y'all know that the grounds for terminating parental rights, really, in Georgia, we often find that we go here with number 5, which is a fairly complex formula. But we also have situations of abandonment. We do have situations of aggravated circumstances. We do have situations in which parents who have been ordered to pay child support by a court have just failed to do so. And so, again, going back to our basic principles, if we look at the issue of attachment, we want to preserve attachments between children and their families whenever possible. But if that is not possible because of the parent's actions or inactions or competence or incapacity, then we need to move quickly to help that child find another attachment. And it also means that when we as the state, we do need to be very careful about reaching into this parent-child relationship. And when we do it, we need to make sure that we are first looking at how we can help the parent, secondly looking at how we can help the family, the extended family to care for the child, third looking at what community resources we can build to help that family take care of its own. But again, there are some situations in which if we cannot keep that child in his or her own community with folks who already know them, then we need to take action quickly to make sure that the child does not linger in the system for a long period of time. So I hope this has been helpful to you. You can always email me, talkwithtom@dhs.ga.gov. We always enjoy the opportunity to discuss these issues with all of you out there, and I appreciate your time. Have a good afternoon.